Okay, let's go on the record on cause number DC 2210595 Cantu versus Smith. Counsel, make your appearances.
Yes, Your Honor. Stacy Dunlop on behalf of Laura Cantu, the plaintiff.
Brian Gillette representing the defendants, and with me is Lauren Green from my office.
Michelle Peters for plaintiff Lauren Cantu.
Okay. All right, let's get started.
Okay. Judge, we're here on the defendant's motion for summary judgment. It is both a traditional motion on all claims and a no evidence motion on several claims. I'm going to share my screen.
Your Honor, if we can take up
I'm
some
allowed to.
housekeeping matters before we get into the substance of the motions, I'd like to do that, please.
What housekeeping matters?
Your Honor, one is that in my response to the motion for summary judgment, I asked the court to not consider it today because of pending discovery that has yet to be completed that is germane and essential for a complete response to the motion for summary judgment. Also, Your Honor, there is also, if the court decides to overrule that and go ahead and consider it today, I'm asking the court to consider my motion for leave that was filed or submitted earlier today relating to the summary judgment evidence that was filed in support of my client's motion for response to the motion for summary judgment.
And Judge, I plan to address both of those issues in my presentation. I'm not sure that there's any efficiency by dealing with those separately, but I'm happy to address those first if you prefer.
Yeah, let's address them first. Go ahead and start with the continuance.
Okay, I have a presentation. If I could be allowed to share my screen.
You can.
All right. This case is about plaintiff seeking over $1 million because defendant Kyle Smith yelled at her during a phone call. The plaintiff worked for defendants. She did well initially. She received several promotions. She ultimately became the chief operating officer. And then the defendants believed she started falling short in her responsibilities. There was a 7-minute phone call in October of 2021.
I object.
You're kind of jumping into the merits here, so let's.
All right, I'll skip ahead to.
It is my motion for continuance. I'd like to just be able to present my argument first, as it is my motion for continuance.
And Judge, I would object that the motion for continuance has not been set for hearing. This motion for summary judgment has been set for hearing for well over a month now.
It's in my response, Your Honor, for the.
I'm going to consider the motion for continuance, so let's hear argument on it.
All right, Judge, you should deny the motion for a continuance because it is procedurally improper. When a party contends that it has not had an adequate opportunity for discovery before a summary judgment hearing, that party must file an affidavit or a verified motion, and that document must explain the need for further discovery. There's no affidavit here. There is no verified petition or motion. There is no explanation of what it is that Ms. Yvonne Garcia would say in a continued deposition, and she was deposed, Your Honor, back in early December. Plaintiff has not offered any explanation for what she would say that she has not said. She's not explained how it would impact the summary judgment before the court today. Moreover, plaintiff is the one who noticed her deposition back in December. Plaintiff asked questions first, and plaintiff completed her questioning and passed the witness. It is only the defendants who were interrupted in their questioning so that Ms. Garcia could go attend to a meeting. And since early December, plaintiff has made exactly zero effort to obtain a second deposition of Ms. Garcia. Moreover, Ms. Garcia testified that she is friends with the plaintiff. And because she appeared voluntarily for her deposition, it is also very likely that plaintiff would be able to obtain an affidavit or a declaration from Ms. Garcia, or that she could obtain her voluntary deposition. But she didn't do any of these things. There's been no effort at diligence in order to justify further discovery on this issue whatever the issue might be, because there's been no explanation presented as to what it is that Ms. Garcia would say that matters for purposes of this ruling.
Response or?
Yes, Your Honor. Thank you. This requirement of a declaration does not apply in this case because, Judge, it's not that we haven't had an adequate opportunity to have the discovery. It's that the discovery has been commenced but has not been completed. In so much as the deposition of Yvonne Garcia is still pending. It was an agreement that Mr. Neely, who was the attorney for the defendants, requested that we not finish Ms. Garcia's deposition and that we reschedule it at another time. Ms. Garcia was appearing by Zoom, and there were some connectivity issues that prevented the questioning to be heard by her sometimes, or for us to understand what she was saying at some times. Yes, Ms. Peters passed the witness at some point, and Mr. Neely began questioning. But if he had, once he would finish questioning, Ms. Peters would have had an opportunity to redirect. That opportunity never did happen, even though that there were some times when questions were offered by Mr. Neely. Ms. Garcia's deposition is essential to my client's claims, because
Mr. Dunlop, what case law or you said that it doesn't apply the requirement to file an affidavit or a verified motion for continuance. What case law do you have that would support your position that that requirement is not applicable here?
Because, Your Honor, well, just if you see the site that's on the screen now that's being shared by opposing counsel, it says that when a party contends that it has not had an adequate opportunity for discovery before summary judgment hearing, it must file either an affidavit explaining the need for further discovery or a verified motion for continuance.
Yeah, I think you're trying to create some kind of exception that doesn't exist. So I'm going to deny the continuance.
Okay.
Let's talk about them. I have not seen the motion for leave, so I'm not sure what that's about.
The motion for leave, Your Honor, is relating to how my response for summary judgment makes reference to the supporting evidence, which is 6 deposition transcripts and 1 declaration of my client. The motion for leave asks the court to allow more specific, detailed references to the material in those deposition transcripts and declaration in support of the facts stated in the response.
And Judge, I have a slide on this as well that'll illustrate the issue. This is an excerpt of plaintiff's response brief here on the right.
Yeah, I read that, and I was I've never seen anyone do that before, where you just said supporting summary judgment evidence. That's problematic, because it's impossible for me to know kind of what you're referring to. You've got to identify, and I guess that's what you're citing to. You have to identify where in the summary judgment record it makes sense, because judges, we can't just look through if there's like 450 pages or 500 pages of documents after that, to just say, hey, look through those 450 pages, it would be virtually impossible for us to evaluate summary judgments. And so, yeah, I thought that was problematic.
Yes, and Your Honor, there are cases on this because parties have attempted to avoid summary judgment like this before by simply attaching hundreds of pages of materials and hoping that by having a big stack in front of the court will, rather than look at it, simply find a fact issue. But the courts of appeals have been unanimous in finding that parties may not simply attach voluminous records to a summary judgment response. It's treated by courts as no evidence. As I understand the motion for leave, which I've not had a chance to dig deeply into today because it was filed only a couple of hours ago. They've attempted to add citations primarily to Ms. Cantu's declaration, which was an exhibit to the summary judgment response. We have an objection on file to Ms. Cantu's declaration as being conclusory. And so we would ask the court to disregard her declaration, even if it were to grant leave and allow specific designations of her declaration to be included in the summary judgment response.
To be clear, Judge, the discovery, I'm sorry, the declaration was timely filed, and it is supporting summary judgment evidence to the response. Also, what we did not do is just attach voluminous records with no reference whatsoever in the response. In fact, we didn't, there were plenty other records that we could have put in, but it wasn't in an effort to try to just overwhelm the court with too many documents or too many records. So this is a situation where defendants have had all of these transcripts for many, just as long as we have for many weeks. And the declaration does not say anything contradictory to the transcript of Laura Cantu. So there's Laura Cantu's deposition transcript and the declaration. And to be clear, the response to the motion for summary judgment is supported by the sworn testimony from the 6 transcripts and the declaration of Laura Cantu.
I have not seen this motion for leave. Can you share screen that? Because it's not on the system yet.
Yes, sir. I think I can. Let me get it right quick. Okay. If I may share the screen. Let's see. For some reason, it's not showing the name of the documents on, so I just have preview unknown. Let me just see. I think it's going to require me to log out of Zoom and come back in, Your Honor, if I may.
Okay.
It's saying Zoom may not be able to record the contents of your screen until it is quit. You can choose to quit Zoom now or do it on your own later.
Are you trying to record or are you trying to share screen?
When I tried to share screen, when I hit share screen, it shows a whole bunch of my open documents, but it doesn't tell me which one they are. So when I clicked on one of them, it says you have to allow screen recording, and then when I press the little button to toggle for screen recording, it says that I have to quit and reopen.
You've done something wrong, obviously. Try to share screen again, and then just hit the document you want to share.
Okay, let me try it again. Okay. Oh, now it's doing it. Well, let's see here. Here we go. All right. Are you able to see that, Judge?
Yep.
Okay. So
Get down to the meat of it.
okay.
Go down.
The more.
Yeah. Go down. So then A.
Oh, go to Exhibit A. I'm sorry. Yes. let me know just if I'm scrolling too fast.
No, I got it. No, I understand. So what you did basically is you went and kind of corrected the summary judgment response. I hate to grant a summary judgment because someone did their footnotes wrong. So I'm going to give you a couple options here. Go ahead and you can stop sharing.
Okay, thank you, Judge.
Judge, might I respond very quickly?
Okay.
Okay, I'm going to share my screen real quick. I pulled up on Westlaw a case from the Dallas Court of Appeals explaining the standard that you have to meet in order to have a court consider an untimely summary judgment response, like what the plaintiff is attempting to do here. And the standard is that it should be granted, but only if the non-movement establishes good cause. And that means showing that the failure to respond in a timely fashion was caused by accident or mistake and was not intentional or the result of conscious indifference, and a showing that it will cause no undue delay or otherwise injure the summary judgment movement. And their motion for leave doesn't articulate even cause, let alone good cause, or address delay, which is inherent at this point. We're in the middle of the summary judgment hearing, or otherwise require some injury to us. They've served a lot of discovery today as well in some form or fashion. Discovery closes in less than 30 days, so all of this discovery is untimely. But it appears that they recognize that there was not some sort of accident or mistake. They knew that their response brief was due last week, and they were consciously indifferent to their obligations under the rules. So from my perspective, they have not met the standard to justify an untimely supplement to their summary judgment response.
Okay. Okay, so I don't think this is exactly applicable. They did file a timely response. It should have designated the I'm not sure what's going on here. Can you guys hear me?
Yes.
Okay. So what I'm going to do here is kind of give you a couple options. One is we could just go forward with the hearing based on the record that there is with, I'm going to allow the motion for leave. I agree that it's not fair to you, to not be able to respond to their motion for leave. And so I don't mind moving the summary judgment so you have an opportunity to respond to it. Or if you want to just go forward today with the motion for leave being granted.
Out of those, I think we would prefer to move forward today, Judge.
Okay. All right. Have you prepared? I don't know if you've submitted one. Have you prepared an order granting the motion for leave, Mr. Dunlop?
I did, Your Honor. I can email it to you, but I did submit it. I did submit it with the same folder that I
Okay. It just hasn't been processed by the clerks yet. So, all right, let's go and go forward.
All right.
Do you want to argue summary judgment?
All right. So now jumping into the merits, Your Honor. This is a case where the plaintiff, Laura Cantu, is seeking over $1 million in mental anguish and suffering because defendant Kyle Smith yelled at her during a 7-minute phone call. She worked at the defendants, which run a hospice company, and did well initially. She received some promotions. She ultimately became chief operating officer, but the relationship soured. Defendants believed that Mrs. Cantu began falling short in her responsibilities. And then during the phone call, as the evidence shows, and I have the excerpt at the end of this presentation, defendant Kyle Smith yelled at her to do her blanking job. Unfortunately, at the time of the call, plaintiff's teenage son was in the hospital for heart failure.
Did Mr. Smith know that when he made this call?
If you're asking me, Judge, yes.
Okay.
The plaintiff was terminated. there's a dispute about whether she resigned during the call or was terminated a few days later. For summary judgment purposes, you'll need to accept that she was in fact terminated a few days later. Within days, she obtained a new job. She worked full-time and she was promoted. For this phone call and termination, the plaintiff seeks $7,504 in economic damages, reflecting unpaid paid time off, and over $1 million in mental anguish damages. In our motion, we argued why each of plaintiff's claims fails as a matter of law. We explained that counts 1 and 2, which are statutory torts, do not meet the statutory requirements. That 5 of her claims seeking PTO are barred by collateral estoppel because she has already litigated and lost that issue before the Texas Workforce Commission, which denied her claim, finding that she was not entitled to any unpaid PTO as a matter of contract. She did not appeal that or otherwise seek to challenge that. And so that is collateral estoppel. There are 4 claims for which she seeks mental anguish damages, but the summary judgment record establishes that she does not have mental anguish damages, that she does not meet the minimum legal standard required to establish mental anguish damages. There are 2 counts for fraud and conversion that seek PTO and are barred by the economic loss doctrine because the PTO is a contract claim. Count 6 is tortious interference with prospective relations, but there is no prospective relationship that she's identified or otherwise supported. She, in fact, immediately got a new job after termination.
So let's go through these one at a time because I think that's the most appropriate way to do it. So let's go through count 1.
Sure. But I would like to point out, Judge, that if you read plaintiff's response, it does not address any of these arguments. None of these arguments are addressed.
Okay, let's go through count 1.
Yes.
I know the summary judgment standard. Count 1. All right, so 161.134
of the Health and Safety Code.
Okay.
This claim fails because there is a 100-day limitations period after the time that a plaintiff files a report. And plaintiff alleges in her petition that she filed a report in late 2020. She was in fact terminated in early November 2021, and she did not bring this suit until August 2022. If you go by the latest possible date of November 3rd, 2021, she filed suit at least 100 days too late. So count 1 is barred by limitations.
All right, response?
Thank you, Your Honor. There is, to be clear, there is some dispute as to when exactly was she terminated, and we don't know the exact date of that. At least I don't think right off of my memory there, but that's my response, is that we don't know exactly the date that she was fired.
There's record evidence.
Wait, let me ask him a question. So in the summary judgment record, did you make any allegation as to what the date was?
Let me see, Judge. We make reference that she was fired while she was on FMLA leave.
You give a date of when you guys are claiming that she was retaliated against, or
not in her declaration. Let me see if in her transcript. Yeah, and I think as close as we get is that she says that she was fired while she was on FMLA. And I don't see that we give an exact date.
And is there any, I don't remember you even discussing this statute of limitations issue. Did you discuss the statute of limitations issue in your response?
I will admit, Your Honor, I did not.
Okay. Count one, the summary judgment's granted. Let's go to count two.
Count two is a wrongful termination claim under the Human Resources Code, section 48-257. There are two issues here. First, the plaintiff had to actually file a report. In order to be liable for this tort, it has to be retaliation against a person for filing a report or providing information in good faith relating to the possible abuse, neglect, or exploitation of an individual receiving services.
It says may retaliate against a person for filing a report or providing information in good faith. There's not a report requirement. It could be either, right?
It could be, but plaintiff admits that she never filed any sort of complaint to the state of Texas relating to this issue, Judge.
And-
so that's the first argument.
Right.
And then the second argument
Before,
is that this section.
Go back to the first one.
Oh, sure.
with respect to that, Your Honor, and as it says there, she did, and the declaration and the response and the transcript of Ms. Cantu reflects that she did make a report or provide the information to her superiors, Kyle Smith and Jordan Smith, when she provided the body minutes of a governing body minutes to them regarding these two specific things that she was concerned about. And so she did provide that information in good faith to her superiors.
All right, let me see the next argument.
And the next argument is that this chapter relates only to a report of elder abuse. Elder abuse is the key criterion, that the retaliation has to be relating to the possible abuse, neglect, or exploitation of an individual receiving services. That is a person 65 years of age or older. And those are defined terms: abuse, neglect, or exploitation. Abuse refers to inflicting physical harm. Neglect refers to not providing them with care that they're entitled to or need to stay alive. And exploitation refers to financial exploitation, stealing from them, taking their stuff. But there was no abuse, neglect, or exploitation here.
What wasn't there? If there's a proper kickbacks, couldn't that be a form of exploitation?
It is not exploitation as provided for under the Human Resources Code, which refers specifically to exploiting an elderly person's financial resources. A kickback would be receiving improper benefits from a third party in order to obtain a patient that you otherwise would not have. So
Right.
that does not qualify. And at any rate, Ms. Cantu admitted.
Is that the remainder of your argument on count two?
It is, Your Honor. Ms. Cantu admitted that she was not concerned about the quality of care.
Count two is count two, the summary judgment's denied. Count three. Do you have a slide on count three?
So count three is is the tortious interference claim, and it seeks only mental anguish damages. So those are all addressed together, Your Honor. In order to establish mental anguish damages, the plaintiff has to provide evidence of a substantial disruption in daily routine or a high degree of mental pain and distress. And this can be direct evidence of the nature, duration, or severity of the plaintiff's anguish, thus establishing a substantial disruption in the plaintiff's daily routine, or other evidence of a high degree of mental pain and distress that is more than mere worry, anxiety, vexation, embarrassment, or anger. And there is no disruption in daily routine whatsoever. The plaintiff took no time off after her employment with Holy Savior Hospice. She worked 40 hours a week at her new job from November 2021 through at least April 2022. She received positive feedback about her work performance there. And the only reason she missed any work during any of this time was to care for her son, which has nothing to do with the defendants. There's also no evidence of a high degree of mental pain or distress. There's no evidence of her seeking psychological counseling or a psychiatrist at all. Her only mental health treatment is unrelated. It's relating to PTSD stemming from her time in the military. Her evidence of using medication is that she intermittently used Prozac to treat depression, but stopped in December 2021. And she occasionally uses Adderall for concentration issues, which has nothing to do with any sort of mental pain or anguish.
All right, response
But
about, no, let's do it one at a time. So mental anguish, what evidence have you shown of mental anguish?
Yes, Your Honor, in her declaration and in her transcript, her deposition transcript, Ms. Cantu makes reference to how while she was at her son's deathbed, her son did not die, but they thought that he was going to die because he had congestive heart failure and that he needed a heart transplant. And so while she was there with him and at the hospital on leave, believing that at any moment that he may pass, she received this phone call from Kyle Smith, and he, while he knew that she was there, while he knew what was going on with her son, and knowing that she was on leave, he went into this tirade with the effect of, or with the purpose of trying to make Ms. Cantu crumble and to quit so that they wouldn't have to keep her on leave and so that they could fire her for also for making the report about the dual skilling and the unethical referrals. She makes reference how that in her deposition transcript and in her declaration that she suffered extreme mental anguish and emotional distress during this period of time. She acknowledged that that it was extraordinarily hard for her, and she to this day still relapses into the moments of those days when she was treated as she was by Kyle Smith and in his own individual capacity and as his capacity for the companies that are the defendants.
So what evidence is it there of a substantial disruption to her daily routine?
Well, her routine had been disrupted in so much as she was on leave and her routine was being at her son's bedside. So it wasn't the, hey, being able to go to work normal routine. It was the being taken from her routine of being right there by her son's bedside, being able to concentrate only on her son's care and being able to take the full benefit of being on FMLA. That was disrupted by Kyle Smith intentionally and knowingly with the purpose of inflicting emotional distress and mental anguish on Miss Cantu. So it's not that she forever was unable to get back to her daily routine or that she was forever never being able to go back to work, but that when Kyle Smith made that call, it substantially disrupted her routine, her daily routine of caring for her son and being able to be by his bedside with no concern whatsoever about her employment. She didn't have any concern about her employment or her income or how she would be able to take care of herself or her son should he survive. That is the substantial disruption in her daily routine.
All right, I'm going to still deny the summary judgment on count two. I will tell you this, Mr. Dunlap, because this came up in a trial I had recently. Assuming that this is correct, I think, what Mr. Smith did was a lot of people would feel was pretty horrible. I had a case very similar where somebody was selling a dental practice and the person who bought it did some stuff that the jury felt was pretty horrible and awarded mental anguish damages. The standard for mental anguish damages is very high, and there wasn't that much evidence in the trial court. The Court of Appeals reversed the the verdict, the jury's verdict. And so if you're going to be trying this on mental anguish, you need to make sure that you're really familiar with this opinion that's shown here and that you meet that standard, because I uh, I was a little surprised the Court of Appeals reversed on that, but I think they're right. It is a very high standard to show mental anguish, and so just kind of be aware of that. But let's go to count three.
Thank you.
Yes, Judge. Let me very quickly.
Let's go to count three, please.
Yeah, so Judge, count three is tortious interference, and mental anguish is the only damages she seeks for that, but mental anguish is not.
She can't. This is the one where you also can't interfere with your own contract, right? This isn't prospective relations. This is just a basic tortious interference.
Yes, just general tortious interference.
Right, I'm gonna grant that one. I don't think you can tortiously interfere with your own contract. So let's go to the next one. Count four. I'll grant on it.
Your Honor, it just presumes that Kyle Smith is one and the same in his individual.
I'm ruling on count three is granted. Let's go to count four.
Thank you, Your Honor.
Okay, Judge, count four is a breach of contract. Count four is breach of contract, which is barred by collateral estoppel. The contract claim is that she had a contract that obligated the defendants to pay her unpaid PTO. That claim, count four, was denied. It was pursued in the Texas Workforce Commission, and it was denied. The TWC explicitly found that she was not entitled to 112 unpaid PTO hours that she's seeking to recover in this lawsuit. She admitted she did not file an appeal of that claim. The Workforce Commission's findings are right here. Based on their interpretation of the written policy or written agreement, the claimant is not entitled to the PTO. This claim is barred by collateral estoppel because collateral estoppel applies where the facts sought to be litigated in a second action were fully and fairly litigated in a first action. The facts were essential to the judgment in the first action, and the parties were cast as adversaries in the first action. And all these elements are met. In fact, the only issue.
Let's talk about that real quick. So this was a Workforce Commission decision, correct?
Yes, Judge.
All right. And so under the Workforce Commission, there's a right to appeal that to a district court, correct?
There is.
But they did not appeal.
They did not appeal it, Judge.
So is there any case law that talks about a situation where there isn't an appeal? Does the decision of the Texas Workforce Commission have the same effect for collateral estoppel purposes as a decision of a district court or county court?
So in our brief, we've cited a number of cases finding that administrative findings do trigger collateral estoppel effects. In the Turnage versus JPI multifamily case, out of the First Court of Appeals, cites a number of other cases applying such findings. We've also cited a PUC case out of the Texas Supreme Court that applied it to a PUC order. And there's clear case law that administrative decisions are treated as judicial decisions for purposes of collateral estoppel, as long as the other elements are met.
Response to count four?
Yes, Your Honor. Rolling Meadows is not the only entity that my client worked for. She worked for, at a minimum, TJS Management as well. And so that TWC finding or ruling would only apply to Rolling Meadows, as it indicated on the slide that Mr. Gillett just showed you.
Yeah, explain that to me, I guess. The PTO, she was working for more than one company at once?
That's
was
right.
She accruing PTO in both the companies or just one of the companies, or how did that work exactly?
So the short answer is she was COO of Holy Savior, and Holy Savior was this conglomerate of all of these entities, or at a minimum, Rolling Meadows and TJS. So this notion that she she was only having PTO through Rolling Meadows is not accurate. However she was employed as COO of Holy Savior, that included basically TJS, Rolling Meadows, and the other entities that would otherwise be part of the Holy Savior group. And so this one entity, Rolling Meadows, would
So
not.
let me ask this: so which company is it again that you said you don't think collateral estoppel applies to?
At a minimum, TJS and the other Holy Savior entities.
And are those parties in this case?
Yes, Your Honor.
And
Okay.
Judge, we've cited the Cisco case in footnote 44 on page 18 of our motion, which explains that strict mutuality of identity is not required for collateral estoppel to apply. The plaintiff in this case has made a point of arguing that all of the defendants are in fact one and the same, that it's a single business enterprise, which is not a valid theory under Texas law. But she's essentially trying to have it both ways. When it benefits her, all the defendants are one and the same. And when it doesn't benefit her, they're all very separate, and you need to parse them out very carefully and treat them very differently from each other. And that is not the law as it applies to collateral estoppel.
I guess my question is, I guess it doesn't matter, but it does seem a little odd that why was this only this one entity bringing I guess she made a claim for benefits under the Texas Workforce Commission, right?
Yes, that's my understanding, Judge.
And it was against this particular entity, is that right?
Yes.
But there were other entities that she may have been accruing PTO. You see what I'm saying? It's like, can you make a claim for PTO without going through the administrative procedures?
I have not seen anything that says that she could not. But to Miss Cantu is a nurse who has a lot of knowledge in, the treatment and care of patients, but she did not have a lot of knowledge about corporate structures and how all of this stuff worked as far as the corporate structures were going. So when she filed this with the Texas Workforce Commission, she was going with what she thought she was supposed to do. We learned during the discovery, while doing our due diligence to prepare the original petition and the First Amendment petition, we learned about many of these other entities. But before she even hired us, she knew about TJS, Rolling Meadows, and Holy Savior Hospice. And she was the COO of Holy Savior. And there's deposition testimony of Yvonne Garcia and others, including Brenna Romine, that talk about how these entities really, in essence, share employees, share office space, share licenses, share, and in essence, it's hard to know who your employer is. In fact, Miranda Peck, another person whose deposition transcript is attached, also talks about, she's a current employee of Holy Savior. She talks about, and she's the current COO. She replaced Ms. Cantu as the COO. She talks about in her transcript that she works for Holy Savior, and that really, whether it's Rolling Meadows or TJS, she's representing, and she's the COO of Holy Savior. And there's a question as to who that really is. And from our perspective, that really boils down to being Kyle and Jordan Smith.
All right, so I'm going to go ahead and grant as to the defendant that was in the Workforce Commission appeal, denies the defendants that were not in the Workforce Commission appeal, but I think it does raise an issue of, is there a requirement to exhaust administrative remedies to begin with? I don't know if you can bring this case without doing that, but that isn't I don't think the subject of this summary judgment. So for now, the summary judgment is denied as to those defendants. Count 5.
Yes, Judge.
Do you have an argument on count 5?
Well, so it's not broken out specifically by counts going forward. There are some overlapping arguments that apply to multiple counts, but count 5 is a claim for fraud, and there are three main reasons as to fraud. One is that PTO is barred by collateral estoppel. The court, I suppose, could make the same ruling on this claim that it did as
Yeah,
to
so same thing on that.
but there's also other reasons to deny it as to count 5. The first being that the economic loss doctrine bars recovery in tort for contract claims, and PTO is a contract claim. It is a claim that the plaintiff had a contract with a defendant or employer that required PTO to be paid at the end of the employment, and you cannot apply a tort duty onto a contract right. And I have a slide on that. I just found it. It's 25. So under the Texas Labor Code, wages include compensation for vacation pay under a written agreement or a written policy. It is a contract claim. And under the economic loss doctrine, there's no tort duty when the only injury claimed is for economic damages recoverable under a breach of contract claim. And there's a series of cases on that. This applies to counts 5, which is for fraud. And we've cited a case applying the economic loss doctrine to a fraud claim that was really a contract claim, as well as a case out of Dallas applying the same to count 7, which is our conversion claim here. Under conversion is prohibited where subject matter is governed by a contract, and contract law is the only recourse for obtaining that.
I'm going to grant summary judgment on count 5 and 7.
PTO was not the only thing that she was on count 5, Your Honor, was not the only thing that she was claiming fraud on, Judge.
What is she claiming on?
She also said that in her petition, she says that she was misrepresented, that she was on leave and that she would not be fired while she was on leave, and she was. She was also told that she relied on this, that a investigation was actually going to happen regarding the dual skilling and the unethical hospice referrals. She relied on both of those representations to her detriment, and the PTO is just one of those. It's just one of the 3 things that we talk about in count 5.
Response to that?
Those are not actionable representations that induced any sort of reliance, and they're not representations that induced any sort of damages as a result. Ms. Cantu has suffered no harm whether or not an investigation happened. That doesn't affect her at all.
I agree as the investigation. What about the promise not to terminate her while she was on leave?
Well, that's also a contract claim. She's seeking either compensation that she would have received or unpaid benefits, and those are part of the contract claim. And the only damages she's identified for her contract, for her employment, are the PTO compensation, because she was paid for all of the work that she performed for Holy Savior.
What other damages? What other damages are done up besides?
Oh, sorry, Judge.
Besides the PTO, are you claiming for count 5 and 7?
We asked for exemplary damages, and those being the actual damages, exemplary damages relating to the mental anguish and emotional distress that she suffered while she was being, in essence, fired while she was on leave.
All right, I'm gonna grant as the count 5 and 7 summary judgment. All right, what's count 6?
All right, count 6 is a claim for tortious interference with prospective relations, and that's
that's something I needed. So what you originally cited to was that they were bad mouthing her and things like that. but it just cited to just generally the summary judgment record. I want to hear what exactly they did to interfere.
Yes, Your Honor. I will tell you. 1 second. Ms. Cantu talks about, Your Honor, in her transcript and in her declaration, how the Smiths asks other employees of Holy Savior to write letters about Miss Cantu and the bad employee that she was. And I'm trying to find a specific reference, Your Honor. I go to, and she says, it's, on paragraph 31 of her declaration, she says, instead of making things right and hiring me back, the Smith brothers pocketed all but 32 hours of my PTO benefit and continued to trash my reputation and say false and harmful things about me and my character. The Smith brothers even asked some of their employees to write letters about me that were untrue.
And that's everything.
Yeah, yes, she does go into it more in her deposition transcript, but that's in essence, in a nutshell what she is claiming.
So you see up here on the screen, it says that to show tortious interference with protected relations, plaintiff needs to show reasonable probability of entering into a business relationship, intentional tortious conduct of defendants interfering with that relationship, and actual damages. So what relationship is she identified that she couldn't enter into because of this action?
Yeah, and I'll admit to you that the supporting summary judgment evidence, at least in the declaration, does not say that or does not provide that information.
All right, I'm going to grant us the 6. So we've dealt with 7. Let's go to 8.
Eight is her claim for intentional infliction of emotional distress, and that's a gap filler tort that's unavailable when there's another claim.
It's granted. 9. Are you still talking?
Nine is unjust enrichment, which has a similar reason for dismissal, which is that it's unavailable when there's a contract, and there's a contract here that governs a right or lack of a right to recover PTO. And so for that reason, unjust enrichment is not a cognizable theory.
Not 9 is granted. 10.
10 is her claim for civil conspiracy. There's not a predicate.
Well, let's see. Go on with that.
And so on the predicate tort issue, we've made a series of arguments. The court has actually denied summary judgment on count 2. And
all right, so conspiracy is denied as to count 2 and granted as the rest.
But there's a second reason to dismiss a conspiracy claim, which is that a corporate agent cannot conspire with the entity he or she works for.
There's multiple different entities though here, right?
That's right, Your Honor. And their theory is that they all operate together as Holy Savior Hospice.
Count 10 is denied as to count 10 is denied as to conspiracy involving count 2, granted as the rest. What's next?
The remainder, I don't have slides for specifically, Judge, but those are principal agent liability and corporate veil issues that are addressed in our brief. We walk through each of their theories for collapsing the entities together,
I'm
and
not
explain why.
trying to, what do you mean by principal agent liability?
Is that for me, Judge?
Yeah, what is
Yes,
that?
Your Honor. So Kyle Smith and Jordan Smith are biological brothers. And then there are the several other non-human entities as defendants. So to the extent that I did a sort of a belts and suspenders with these other counts after civil conspiracy from the standpoint of that if it's not conspiracy, then Kyle Smith was acting as an agent for the defendants, or Jordan Smith was acting as an agent for Kyle Smith, or it's basically to make certain that I have as the evidence would show that it's either conspiracy or that these persons and entities were acting with the authorized principal agent relationship to do the harmful things that they did to Miss Cantu.
Not sure I fully understand that, but okay. Cause of action, when it granted the cause of action 11 and 12, to the extent they're causes of action, any argument related to count 2 that is related to this, I'm going to allow. So let's go to 13. Was there any evidence on piercing the corporate veil?
There's not anything to address this that I saw in the response brief, Your Honor. But essentially, there's not a predicate fraud. The court has granted summary judgment as to fraud, and there's not a single business enterprise theory that's recognized in Texas. It's barred by statute.
Response?
Yeah, the record and the response talks about how the entities are in essence the Kyle Smith and Jordan Smith's really just alter egos for Kyle Smith and Jordan Smith. The deposition transcript of Yvonne Garcia supports that Kyle Smith and Jordan Smith were the owners of Holy Savior. Miranda Peck reflects that she works for Holy Savior, and that's all of the that's all of the entities that is specifically Rolling Meadows and TJS and other Holy Savior entities. They share the same office spaces, same employees, same equipment, and so, Your Honor, to the extent that they are really just alter egos of Kyle Smith and Jordan Smith, and they should not be able to enjoy the benefit of the corporate veil if the purpose of these entities is really to hide or otherwise frustrate a person's ability to sue them or to collect a judgment against them.
Judge, the entire purpose of a limited liability company or a corporation is to allow a business to operate without making its owners liable if the business commits some kind of tort. On pages 30 through 32 of our brief, we walk through each of the different theories that are asserted in the petition. Sham to perpetrate a fraud, conduit and tool theory, single business enterprise. Every single one of these is barred by a statute or a Texas Supreme Court case or both.
All right, I'm going to grant summary judgment as to the single business enterprise theory. To the remainder of the alter ego stuff, I'm going to deny it for now. We'll see what happens at trial for that, but it'll only be as to count 2 and the related torts and anything else that survives. So I've ruled on everything. Go ahead and prepare an order, Mr. Dunlap. Make sure the order says at the beginning that this was heard on, I think it's February 5th, 2024. Share a copy of the order and make sure I get the order preferably by the end of the day tomorrow.
Yes, Your Honor.
Any questions?
And Judge, just to be clear, Mr. Dunlop is preparing an order on the leave, and am I preparing the order on the summary judgment rulings?
On the leave, it's up to you, Mr. Dunlop. Do you want to prepare the order on the summary judgment? Want opposing counsel to do it?
I would prefer. Well, I prefer to do the order, Judge, for the summary judgment.
you do the order and you share it with Mr. Gillett, and then you guys work it out.
Yes.
You know,
Yes, sir.
may or may not agree with the order, but just make sure it accurately reflects my rulings.